Thank you, Deputy President. I rise to contribute to the Justice Legislation Amendment Bill 2023. This is a bill that seeks to amend several acts in relation to the Victorian justice system to achieve a range of outcomes for the betterment of Victoria's court system and for Victorians. Before jumping into the substance of the bill, I'd like to commend the work of the Attorney-General. This is a very well put together bill that addresses several important issues within the Victorian courts and justice system. It is wide-reaching, ensuring that several deficiencies in our justice legislations are addressed. Due to the wide-reaching nature of the bill, a broad range of parts of the legal system will be covered. Deputy President, let's not forget where this bill comes from. It is in no small part due to the coronial findings of the inquest of Tanya Day. The coronial inquest into the death of Tanya Day highlighted several changes that needed to be made to our legal system, and I'm proud that the first measure of the Allan Labor government is this. It demonstrates a commitment of a government that is serious about improving the lives of all Victorians and the functioning of our court system. A key part of drafting legislation is consulting with experts, which is exactly what has happened in the process of creating this bill, and listening to what they have to say. Getting it right into the substance of the bill, we start to show how an Allan Labor government is addressing recommendation 2 of the coronial report. For those in the chamber who have not taken the time to familiarise themselves with the findings of the recommendations of the report, recommendation 2 pertains to the provisions of clarity by the legislative body. Specifically in this regard, for the defined roles of police coronial investigators within coronial inquests into the reportable deaths. The coronial inquest found that there was not enough clarity in our justice legislation surrounding the roles of police coronial investigators. As of this stage, the role of the police coronial investigator in our justice system is regarded to be largely informal and driven by convention rather than outlined roles and responsibilities. The bill seeks to fix this by implementing in our legislation the exact rights, roles and responsibilities of a police coronial investigator and how their relationships will function with both the Coroner's Court and Victoria Police. This will be executed specifically by amending the Coroner's Court Act 2008 within Section 3 of the said Act. To read from the bill, Deputy President, starting at Clause 12 of the bill in discussion in Section 3(1) of the Coroner's Act 2008, insert the following definitions. The Chief Commissioner of Police means the Chief Commissioner of Police appointed under Section 17 of the Victorian Police Act 2013. 10 coronial investigators means a police officer who is nominated by the Chief Commissioner of Police to assist the coroner in relation to the investigation of a reportable death. The definition of coronial investigator provides a coronial investigator is a police officer nominated by the Chief Commissioner of Police to assist the coroner in relation to an investigation into a reportable death. This clearly outlines exactly what a police coroner is. The bill then goes on to outline the roles and privileges of a police coronial investigator, includes Clause 13 of the bill. Essentially, this clause of the bill outlines the coronial investigator is answerable and must comply with orders set out by the coroner. Obviously, this is a convention often followed, but it is important to ensure that such a provision is in fact legally binding. To expect our legal frameworks to be anything but strong would be a disappointment to the Victorian people, and for that purpose we must strengthen our laws to ensure compliance. This is effected specifically, as I stated, under Clause 13 of the bill by inserting a new section, Section 15A, under Section 15 of the Coroner's Act 2008, titled The Power to Direct Coronial Investigator. If I could read from that bill again, 1. A coroner by written notice may direct a coronial investigator in relation to an investigation in a reportable death. 2. Subject to subsection 3, a coronial investigator must comply with a reasonable and lawful direction under subsection 1. 3. A coronial investigator is not required to comply with a direction under subsection 1. It is the Chief Commissioner of Police gives the State Coroner written notice that the Chief Commissioner considers the direction to be unreasonable or that complying with the direction would be likely to compromise a criminal investigation. 4. A notice under subsection 3 must be given within 14 days after the direction under subsection 1 is given. This bill also takes note from several other sources, not just the Tanya Day coronial inquest. This bill also gives effect to recommendation 26 of the Royal Commission on Aboriginal Deaths in Custody and recommendation 42 of the Victorian Parliamentary Law Reform Committee review of the Coroner's Act 1985. These are both very important inquiries into exactly how to fix unacceptable ongoing issues that result in the disproportionate representation of Aboriginal people, especially women, in our justice system. Recommendation 29 of the Royal Commission into Aboriginal Deaths in Custody, a Royal Commission that is government continues to take extremely seriously, acknowledging the weight of the subject matter that it deals with. And the ongoing need for action it presents relies from the findings within the Royal Commission. Recommendation 29 is as follows: that the coroner in charge of the coronial inquiry into the death in custody have legal power to require the office in charge of the police investigation to report to the coroner. The coroner should have power to give directions as to any additional steps he or she desires to be taken in the investigation. In empowering our coroners hold specific powers over the relevant officers in the investigation into reportable death, this recommendation would be implemented into Victorian law and recognises that the need that the coroner must hold certain powers over the police during the investigation to fully explore all investigative avenues. This recommendation was implemented some time ago, and these amendments only seek to embolden the principles and the needs set out in this recommendation. Additionally, the bill seeks to improve the functionality of several pieces of Victorian legislation pertaining to the justice system and eligibility for spent convictions and other miscellaneous needs for amendment in the Spent Convictions Act 2021. At the current state, there are unintended legislative limitations to being eligible for spent convictions. Spent convictions, of course, being a conviction that will not be disclosed on a police check, functionally being wiped from your record. A spent conviction must meet several criteria. It must be a conviction that of older than 10 years, a period in which the offender has not reoffended. In the instance in which the offender has reoffended, the waiting period resets and they must wait an additional decade. The offender must not have been sentenced to imprisonment for more than 30 months, and finally, a statutory or prescribed exclusion to the conviction being spent. It should also be noted that the waiting periods for juvenile offenders is only 5 years. The spent conviction scheme is an incredibly important aspect of our justice system, as it acknowledges the importance of rehabilitation and gives offenders a chance to put their crimes behind them and lead a better, more rewarding life. Currently, Victorian law and the Spent Convictions Act 2021 stipulates that children and young offenders must be sentenced under specific legislation to be eligible for automatic spending of conviction after the full 5 years of non-offending is observed. This extends to children and young offenders who commit more serious crimes and must therefore apply through the Magistrates' Court to have their convictions spent. Of course, with the intention of young offenders are given every opportunity to rehabilitate themselves. It is important that there are legislative frameworks that supply these young Victorians with every opportunity to put their criminality behind them. This ensures that legal frameworks allow people to turn away from crime, ultimately lowering the rate of crime in the state. This will be exercised by ensuring that all children and young offenders of lesser offences are eligible for their convictions to be automatically spent. Additionally, this bill amends the Spent Convictions Act 2021 to give clarity to the definition of the terms of imprisonment. The current definition of the term of imprisonment extends to alternate types of imprisonment, therefore not providing the more focused gauge of an offence. As traditional imprisonment and house detention would be dealt with for offences of varying seriousness, this catch-all measurement of imprisonment does not best reflect the nature of a crime. To that effect, this bill introduces a new definition, custodial term. In the Act shall read an order that the person serve the term of imprisonment or detention in the Youth Justice Centre or Youth Residential Centre, or a court secure treatment order. This will now be applied in the metric by which 30 months of imprisonment is measured in Victoria. This will ensure that there has been a standard line for the seriousness of the offence ineligible to be classified as spent, whilst also promoting rehabilitation. Further improving the state Victorian courts, this bill will introduce increased protections for consumers in the legal service market. Victorian legislation is currently unclear as to the application of the legal professional uniform law, specifically in relation to the prosecution of the offences of causing a deficiency in trust account in the improper destruction of regulatory property. This bill will clarify that the indictable offences triable summarily. Each offence can result in a maximum of 5 years imprisonment or up to 500 penalty units. These penalty units exceed those that fall under the magistrate's call, but the linguistic quirk in the legislation means that in Victoria they are classified as summary offences and therefore hold a 12-month limitation period for prosecution. This leaves the courts with a major dilemma resulting from the very nature of these crimes. The investigation and prosecution of these crimes are often subject to significant delays due to the complex nature of the trust accounting. The current setup is entirely inappropriate, and due to the penalty there is no reason why these crimes not be heard before a higher court. Under this bill, the two crimes classified in indictable offences, they will be heard before a higher court, and therefore the prosecution of these offences will be far more efficient. This will promote consumer protection by ensuring that these crimes are prosecutable. What good is a penalty and offence in our law if its functionality impossible to properly prosecute an offender for it? What justice does that bring to a legal client who has fallen victim to an improper destruction of regulated property and deficiency in a trust account? This bill further amends legislation in relation to that legal professional uniform law. It alters the framework of disciplinary action and the registry action for Victorian lawyers. This update to the legislation will bring Victoria's legislative framework surrounding the register for disciplinary action against Victorian lawyers will be in line with the jurisdiction subject to the legal professional uniform law scheme. Additionally, it will of course promote consumer protection in the legal services. The specific issue in the bill hopes to amend the Victorian Legal Services Board inability to publish details of unsatisfactory professional conduct. The Legal Professional Uniform Law Act 2014 stipulates that the board cannot publish findings until an appeal has been determined is expired and no time limit is currently specified. This bill will introduce a time limit of 28 days to appeal a determination. This bill will also for the immediate publication of the outcome on the register and the immediate retraction of disciplinary action reporting on the register in the case that an appeal is successful. Additional amendments made with this bill include modernisation registry to support the rollout of the case management system in the family division of the Children's Court, updating several jury directions relating to consent so as for them to be more helpful and accurate for juries, and clarifying them are available for all sexual offence trials, allowing certain authorised officers to witness statements in criminal prosecution briefs and specifically authorised officers, Prime Safe and Dairy Food Safe Victoria, as this stage of Criminal Procedure Act 2009 does not permit these offences to do so, leaving the burden solely to police officers. Addressing various legal and procedural issues in respect to the Victorian Civil Administrative Tribunal's jurisdictions that were brought in light of the Thurin versus Congold case, and expanding the presumptive rights scheme to include 3 additional cancers affecting female firefighters, especially cervical, ovarian and uterine cancers, a commitment made by the government earlier this year. On this note, I note the strong advocacy of the United Firefighters Union, the Australian Services Union and the Victorian Fire Brigades Victoria. I've met with several representatives from the UFU specifically and recognise their passion in expanding additional female cancers. I'm grateful for all stakeholders interested in this bill and their consultation and their work to ensure that we are making a difference. It is thorough in its proposed changes in the Victorian law surrounding the justice system, and I commend everyone involved in drafting this bill. I urge my colleagues in this chamber to support this bill, as the alterations as it makes the legal system in Victoria will undoubtedly have very positive effects on the functioning of our courts. It will right the wrongs of the past and ensure that vulnerable people are not more negatively affected by the courts and the legal system that they use. I commend the bill to the House. Thank you.